RACs are really here to stay, and they're certainly not going away right now. So they've been very active, the Medicare RAC in particular, with audits and recovering money from hospitals. So we want to encourage hospitals to appeal those particular decisions, particularly where they have cases that they believe have merit. We've seen a lot of success with appeals, but many times that success doesn't come until you reach the ALJ level. There are some that are overturned at the first and second level of appeal, but not very many. But when you get to the ALJ level, many of them are overturned. And in fact, the American Hospital Association reported in a letter to the OIG that 75% of appeals are ultimately overturned. We want you to appeal those, and we know that many hospitals are going to do the first and second level of appeals on their own. So our advice to you is to be very diligent about how you put that evidence together, because once you finish that second level of appeal, at the ALJ level, you're not allowed to introduce new evidence unless you can show good cause. And it's becoming harder and harder for us to show good cause at that level. I'm going to repeat something Diane said because I think it's worth repeating, is when you're putting that together, when you're putting your evidence together at those first two levels of appeal, make sure you include a physician statement. That's very important to these medical necessity cases, to even the coding cases or any of the one-day stay cases, because when you get to the ALJ level, and if you involve an attorney like me that goes to that or conducts that hearing for you, I'm going to want a physician witness. There are very few administrative law judges that are going to impose their judgment over the testimony of an expert physician. So if you can give me an expert physician to testify to the medical necessity or to whatever the issues are in that case, we can win those appeals. The American Hospital Association has been taking a very active role in these RAC appeals and fighting for the hospitals. One of the things that happened on October 21st of 2012, the American Hospital Association sent a letter to the OIG, and it started out praising the OIG for the inclusion in their work plan that they were going to review the effectiveness of various Medicare contractors, including the recovery audit contractors. Now, then the American Hospital Association went on to say in that letter, but first, these inappropriate denials of payments by the RACs must stop. And then they went on to urge the OIG to look at streamlining all the integrity programs and eliminating the duplication of audits that are occurring. And they talked about the burden on the hospitals for having to respond to all those duplicative audits and also having to appeal in order to get their money back. Then they turned around on November 1st of 2012 and filed the lawsuit that Diane mentioned against the U.S. Department of Health and Human Services. And in that lawsuit, they claimed that Medicare's refusal to pay hospitals for hundreds of millions of dollars for care delivered to Medicare beneficiaries is unlawful government practice. The main allegation in that complaint was focused around what they're calling Medicare's payment denial policies, in which Medicare is refusing to pay for Part B services after RAC has denied the Part A level of service. The complaint basically stated that the payment denial policy of Medicare is not in accordance with the Medicare Act, so it was invalid and should be stricken. But anyway, the Affordable Care Act extended the RAC program to Medicaid. So people are starting now to get letters from the Medicaid RAC, which is CGI, for audits and for record reviews. There is an appeal process in this as well, a three-level appeal process, but you need to really look at that if you're going to appeal any of these Medicaid. Now, it's too early for us to give you information or advice about them because they're just getting started in Ohio, and we haven't had decisions yet that we've appealed. But the timeline for filing your appeal is very short in some cases, shorter than it is under the Medicare Act. So you really need to look at that because between the first level to the second level, you have 60 days. The second level to the third level, you have 30 days. But then when you go to appeal for the third level, you only have 15 calendar days from the date the decision was issued. Not the date you received it, but the date it was issued. So you do have to look at that if you're going to be appealing those in the future. Thank you.